Good morning to all of India, to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Friends, we are going to discuss a case relating to Section 188 of the CRPC. Please remember, CRPC, very good judgment from the Supreme Court. Normally, you don't get judgments in this regard. We get so many judgments regarding Section 188 of the Indian Penal Code. That is a public servant. Whenever his orders are violated, the public servant is the competent authority to file a complaint, not the police officer. That means if any person violates the orders given under 144 CRPC, the concerned person like Tahsildar or RDO has to file a complaint under Section 188 of the Indian Penal Code. He is only the competent person, not the police. But here it is another section, 188 CRPC. So very good judgment from the Supreme Court. So Supreme Court observed that Section 188 will not be attracted if any part of the offence is committed in India. This is important. So while disposing the case of Sartaj Khan, S-A-R-T-A-J, Sartaj Khan versus State of Uttar Pradesh, 2022, in criminal appeal number 252 by 2018. So you can see it in live law 22 SC page number 321. So this judgment came on 24/3/2002. So three judgments, Justice Uday Umesh Lalit, then our Pamdi Ghantam Srinivasa Narasimha and Ravindra Bhatt. They clearly held that Section 188 gets attracted only when the entire offence is committed outside India. Then sanction is necessary to conduct trial of such offences. But any part of the offence is committed in India, not necessary. So if you know the details of the case, it will be easy for you to appreciate. But before that, let us study Section 188 CRPC. Please remember, when any offence is committed outside India by a citizen of India, whether on the high seas or elsewhere. So if any Indian citizen commits an offence on the high seas or outside India, or by a person not being such citizen on any ship or aircraft registered in India, that means outsider. Please remember, he may be dealt with as though he had committed the offence within India. Simply to say, within India, he may be found. So please remember, for this person with the previous sanction of the central government. This is important point. So please remember, if any offence is committed outside India by an Indian, or if any offence is committed by a non-Indian or non-citizen of India, definitely he can be tried as though he committed the offence in India. So what section you are getting thought of once again? Section 4 of the Indian Penal Code. So almost all same law, Section 4 of the Indian Penal Code, or extradition law. Right. Here the point is, main point, by now you might have understood. Please remember, if the offence is committed outside India, then if the person is arrested in India, he can be tried as though he committed the same offence in India. Of course, this is for the universal offences like murder, rape and other things, not for prostitution or not for this bigamy and others. Right. Now, we'll go to the details of the case. On 10/4/2015, the victim, of course, I should not tell her name. So she is from Nepal. She wanted to meet her uncle. She came to her uncle's residence, which is in the border area. There, the accused person, so actually he got contact with her. He's also, both of them are, they say he's a boy and that girl is she's a girl. So this boy lured her that if we cross Indo-Nepal border, you can go to India and you can go for shopping. I will bear that money. Almost he said so many sweet and lustful words to her, and she believed him totally. And she came to the border. And at the border, what happened is, when there was so much of rush, then simply they have evaded the checking staff by crossing through the stranded vehicles somehow, by saying that they are just going for shopping and come back like that. Whatever they, as actually Madhya Petti, checking staff in Madhya Petti, they entered India. Of course, you may be knowing, there is no thorough checking between India and Nepal. It is a free entry. Right. So the boy brought her from Nepal to Barbansa. This area is UP. It's called as Barbansa. Right. Okay. Now, actually, she has purchased something and she was taken to a hotel. Her room was booked. There she objected the matter. And incidentally, an information was received by the police. They went there, they caught the person and booked him under section 363 kidnapping, 366A kidnapping for the purpose of, 360B kidnapping for the purpose of wrongful confinement, and 370, so kidnapping for the purpose of sale, a very serious offense, 370 clause 4, and also 506, that is criminal intimidation, as well as section 8 of the POCSO Act also they have booked against him. But of course, please remember, so this case, okay, right, now actually the trial court, they acquitted him. The trial court acquitted him. Now, but the High Court in its wisdom, so definitely they have reversed the acquittal and convicted the accused for 7 years, and now they have filed a special appeal or final appeal before the Honorable Supreme Court of India. Supreme Court of India. The argument by the defense is that since the offence was committed in India by a Nepali, please remember, by a non-Indian, so therefore sanction of the government according to 188 CRPC is necessary. This is the objection raised by the defense counsel. This point you must remember. No doubt whether it will stand or not before court of law, whether it appreciated by the court of law is not different, but at least you must know what is the defense you have to put. So here the defense put by the defense advocate is that sanction is necessary as per 188 CRPC. Now the court held that the abduction or kidnapping started from Nepal, but it ended in India. So when the offence, a part of the offence is committed in India, no sanction is necessary. If the offence is committed outside India, that is in Nepal, by an Indian citizen, definitely permission is necessary. Ultimately, to end up, I want to tell you that sanction is not necessary if any part of the offence is committed in India. So there was a previous case, I have forgotten to tell you. So what happened is in Kerala, I think this is a case relating to Remia versus SI Tanur, 1993. Okay, it is relating to 1993. So what happened is one person came to Tanur, Sulem. Okay, so one person came to Tanur PS and he alleged that a murder took place in Sharjah of United Arab Emirates. So here, where the police Kerala refused to entertain a complaint that one Suleiman was murdered at Sharjah in United Arab Emirates by Ali. So Suleiman was murdered by Ali where? In Sharjah. So the offence was committed outside India. So they refused even to take up the case. But now when the matter has gone to the Kerala High Court notice, Kerala High Court directed the police to register the FIR on the basis of the complaint and take steps for the extradition of the accused, because the accused is Ali, is an Indian citizen, right? So please remember, it is further held that sanction of the government was not required at the investigation stage. The another important point, investigation stage, sanction is not necessary, only for conducting trial or only for filing charge sheet. So very important case law. Please remember it, and I think you will enrich your legal knowledge. Normally, under this section, you don't get any judgments, very less judgments. Thank you very much.